Welcome everyone, welcome to the Deal Finder Corner. So this is your weekly property talk show brought to you by Property Filter, hosted by myself, Guillaume Black, your favorite Frenchman, the CEO and co-founder at Property Filter. And as you know, it's the UK's highest rated platform to find deals. And again, on a mission to empower our property investor and deal sourcer members to find a few thousand deals this year, like they did last year, where they got more than 2,200 offers accepted, which was great. So let's beat that this year. And the purpose with these Deal Finder Corners is to give you more and the best of the available resources by inviting expert guests that will share with you the latest, most current strategies, tactics, and secrets about what actually works right now in terms of finding and making deals and the reality of systemizing and running our performance business in property. So it really is my pleasure to introduce you Tony Power on today's Deal Finder Corner. So I've seen Tony spoke a few times. He's a long-standing Property Filter friend. Property Filter friend. And so Tony is a law lecturer at Canterbury Christchurch University, if I got this right, with expertise in...
Christchurch.
Yeah, absolutely. Is that the background you have behind you, or is it more the generic barrister thingy? So you've got expertise in contracts, employment, and property law. He's a law graduate, associate fellow of the Higher Education Academy, and I'll have to let you explain me what is ICILEX regulated for paralegal.
So the Chartered Institute of Legal Executives.
There we go.
It's your third route into law. So solicitor, barrister, or SILEX, the legal executive.
Awesome. And so a diverse experience from being a police officer, a legal trainer, a county court advocate, academic lawyer. He speaks regularly at property investment network meetings, offering insights on contracts for property investors doing property deals. And he created the Through Barrister, which helps property investors and business owners apply legal and contracts, in properly in a way that they can get things done right. And I think we will hear more about Tony in the next edition of YPN magazine, which should be in the mail at the moment, or if not now, in the next few weeks. So very much looking forward to read this as well. So today we specifically are going to talk about construction contracts. So what are JCT contracts, what are they, how to use them, and there's some myths we are going to bust with Tony today, which is great. Key pitfalls that can come at a cost to you, and why blinding, if you are blindly signing a JCT contract, it could cost you quite a bit. And what are the different amendments you can use, and what are the interests. So really interesting on construction side. And I know in the Q&A, this could broaden into quite a few other things. So thanks so much, Tony. Over to you. Very much looking forward to hearing your talk today. So please, everyone, give a massive Property Filter virtual welcome to Mr. Tony Power. Woo! Over to you.
Cheers, Guillaume. Yeah, so I'm an academic lawyer. I'm a little bit unusual. I have trained as a barrister. I teach law at Canterbury Christchurch University, as Guillaume said, but I was also a county court advocate dealing with landlord and tenant repossession hearings. So I was working with property entrepreneurs, and they kept on telling me, get into property, get into property. So hence I ended up with my wife, Sue. We signed up for Property Investors Network, which is where we came across Guillaume, and I've just completed the mastermind program. So I do understand property. I do understand the necessities behind it, both from a legal perspective and also being a property investor myself now. JCT contracts, absolute transparency, like every good lawyer should say. Initially, when I started at PIN, I didn't know what on earth these were. Then I had the amazing pleasure of speaking with Richie Clapson, and he is an absolute master in this area. So, typical academic, I started doing research, and I find that I give a lot of advice to my fellow masterminders now on both standard contracts and also JCTs. So, JCTs, what are they? Well, they are Joint Contracts Tribunal contracts. They're one of the most widely used forms of construction contracts in England and Wales. Now, Northern Ireland and Scotland, yeah, the contracts are slightly different. They have a version of JCTs, but not exactly the same as England and Wales. So whether you're an investor, developer, or contractor, understanding JCTs is fairly crucial. Okay. So what is a JCT and what they actually use for and when to use them? A JCT is a standard form construction contract. And as I said, it's developed by the Joint Contracts Tribunal, and they're used to regulate the legal relationship between parties in the construction project. The JCT outlines the obligations, payment structures, risk allocation, dispute resolution mechanisms, and timelines. So they are the 5 most fundamental things when you're doing a construction that you need to have in place. So hence the JCTs were brought about.
Could you repeat these? The five, Tony?
Yep, certainly. So it's obligations, payment structures, risk allocation, dispute resolution mechanism, and timelines. Okay. So the Joint Contracts Tribunal standardized to a degree these contracts. Now, those of you that have heard me talk on the pin circuit will always hear me say, do not get an off-the-shelf contract. However, this is the exception to the rule. However, they still are required to be fit for purpose and actually fit your project. They're designed to be fair and balanced. They must be tailored to suit the specific needs of the project, though. Okay, so they are adjustable. So commonly used in property developments and construction projects where there is a contractor and employer relationship. So property investor hiring a builder to do a refurbishment, for example. Defined scope of works. Okay, the contract sets out what needs to be done, how it will be done, and who is responsible. It is absolutely clear on JCT who is responsible. Your name is next to that activity or task. Okay. The need for risk allocation. It determines who takes responsibility for delays, defects, and cost overruns. It is not always true that those issues go automatically to the builder. Okay. Sometimes the allocation of risk goes to you. Now, that might be negotiated with the builder, or it may be circumstances that cause that. So there are 1, 2, 3, 4, 5. It works in 5s here. There are 5 types of JCT contract. And it depends on project size, complexity, and risk allocation. Some of the key types are minor works building contract for simple refurbishments and extensions. JCT intermediate contract. Now this, as the name suggests, is for medium-sized projects with some complexity though. For example, I was looking at a property in Canterbury, a lovely arts and craft building. Speaking to a couple of developers, to turn that into 9 flats would be fairly standard. However, there is a basement and some works have been done at the back by the previous owner. So it added a level of complexity. So therefore, it would have been an intermediate contract that I would have used if I would have gone forward with that project. JCT standard building contract. Now, this is for the large scale developments where detailed contract administration is required. So getting the right contract for the work you're doing is essential. You don't want a standard building contract when it's a simple refurbishment. You must get the right contract for the right works. There is also JCT design and build contracts. The contractor takes on both design and construction responsibilities. And we also have JCT measured term contracts for maintenance work over a long-term period. So there are a couple of others as well, which I won't go into now, but knowing which one to use, this is where, having a good legal advisor is always useful. Also, those very experienced who have been doing construction work for a while and are property investors themselves, if you're partnering with people like that, then they will probably have used these contracts in the past and will know which one to use. So reaching out to your network, to those possibly more experienced than yourself, okay, but legal advisor should be able to tell you which contract you should be using, okay. Like every good lawyer, I've got my notes. Any questions so far? Got a couple of things in the chat. Let me pop that over.
Was it the minor works contract,
Yep.
intermediate contract, standard building contract, design and build contract, and what was the last one?
JCT measured term contract.
Okay, measured term. Not, okay.
Yeah. Okay. So the measured term is for the long-term maintenance, ongoing maintenance.
And can you explain Tony a little bit this framework? So I'm familiar with this because this was my day job, back in the day, dealing with NEC contracts for infrastructures and things like that. But basically, why were these introduced? And it's a standardized way of working. They are templated, but they are not off the shelves. You need to fill in the blanks and things like that. Can you sort of explain the history of how did they come about, why they came to be used, and why did that? I'm guessing a lot of people try to do this, and somehow these ones were quite sticky and mainly used for all those residential and private build, sector. Be quite interesting to know a bit more about the background on that.
So JCTs came about because of horrendous amounts of litigation, absolutely horrendous amounts. When building standards came in, prior to that, it was, to use a legal term, cowboy city. Contracts were literally written on the back of an envelope. There was uncertainty, and so many people were taking people on litigation because understanding who was responsible for what was not clear. Contracts were being written up in such a way that they were absolutely loaded to either the builder or to the contractor. So JCTs, let me get my notes back up. Trying to think when they were created.
Oh, it's more anecdotically, like
Yeah, so JCTs were first brought about in 1931, and it was formed by the Royal Institute of British Architects and National Federation of Building Trade Employers. The JCT itself is a body, so the Joint Contracts Tribunal that represents a variety of interests in the construction industry. They were decided as being a leading authority, so they were tasked with, along with lawyers, coming up with JCT contracts, so a standard form of contracts that could standardize across the board so that everyone knew where they were standing with the responsibilities. Revised and published in 1939, 1960.
I think that kind of answers my question. Yeah. Okay, so it's been around for a while, and then you said we need advice to know which form to use, like which of the standard ones on the 5 here.
Yeah. So, I mean, your standard form contracts, you've got also consultant agreements, subcontracts, subcontracts, design agreements, forms of tender, forms of contract for the supply of goods, form bonds, and collateral warranties, just to name a few. There are, I believe, around about 20 JCT contracts that can be used in various situations. Sometimes you may have multiple JCT contracts for the same project. Now, it may be with the same contractor that you're using, dependent on what stage it is, what they're being tasked to do. So, they may actually do the building, but when it comes to the first fix and decoration, another JCT contract would be used at that point. So you may have multiple running into each other JCT contracts as well.
So I'm a property investor and I'm converting 3-bed houses into 6, 7-bed HMOs. Typically, I'm paying 200K for the property. I'm spending 150 on with one main contractor.
Yep.
What would be the form here? Would be the standard one or minor works or?
So the intermediate contract from what you're describing, an intermediate contract would be the one there, because there may be some complexities, but it would be, from your description, a medium-sized project. So you'd be looking at the intermediate contract that covers some of the complexities, but still defines who is responsible for what, and also the timelines. Yep.
Awesome, yeah. Thank you. I'll let you carry on. Yeah. Thanks, Tony.
That's all right. No worries. So let's look at some of the key pitfalls. When you get pitfalls in contract, it can cost you thousands. Okay. If anyone's ever done any litigation before, there's this horrible thing called a cost order. Okay, where you're told to pay the costs of the other side and your own costs. They're very unpleasant things, and they can run in some tens of thousands. So JCTs aren't foolproof. Okay, as a as a legal professional, I have to tell you that they are not foolproof by any means. No contract particularly is. If they're misunderstood or modified incorrectly, they can lead to serious financial risk. Okay. So JC contract outlines stage payments, retention clauses, and final account settlements. Not negotiating clear payment terms can lead to cash flow issues and disputes. Okay. Always check if the payment schedule aligns with your finance agreements. So this is an area where people go, oh, it's a JCT, it's already written down, here we go, sign that. Yet they haven't negotiated clear payment terms. There is ability within JCT to amend the payment terms. One that does trip people up is an adequate scope of work definitions. Many investors fail to specify detailed scope requirements. I have to admit, when I first started with property investment, I didn't realize the actual level of detail. I had a conversation with the wonderful Sam Carter, and he shared with me one of his schedule of works. It was mind-blowing, absolutely mind-blowing, the detail that Sam went to. But when you see the end result of Sam's work, you can understand why. So failing to specify the detailed scope requirements can lead to rather costly variations in the contract later on down the line. The variations will usually result in a claim from the contractors as well. Ambiguous contract wording can allow contractors to charge extra for work that should have been included. So ensuring a precise description of work, materials, and timelines. Each JCT contract has the ability to insert that, or it may be a case of writing in JCT see addendum. So it may be a separate few sheets of paper with those work materials, timelines, etc. specified. Overlooking delay and liquidation damage clauses. Delaying construction can cripple a project's profitability. And we should know that as property investors, these things do happen with building projects. Delays happen. Okay. Sorry, that's the wife. Standard JCT contracts do not include automatic penalties for delays. This is something that when people see it's a nicely bound contract in a book format, most often they think, oh, it's all complete, and promptly hand it over, just sign the signature page and hand it over. And then when there is a delay, the builder goes, well, there's nothing in the contract about a delay clause. So it is essential that you read through the JCT contract that you get. You must add a liquidated damages clause to protect yourself. Without this clause, if a contract delays completion, you could face huge financial losses with no legal resource. Okay. Oh, sorry, recourse, not resource. Okay. So if the builder delays, forces you into liquidation, it gives you the right to litigate to regain in the least some of that money back. Misallocation, risk and responsibilities. The JCT is renowned for dividing responsibility for defects, delays, and site conditions. As an investor, it's your job to clarify liability for unforeseen issues. Okay. The legal term is force majeure. Okay. So I hope I said that correctly. So yeah, the force majeure clause in a contract is basically act of God. All right. So a force outside of your control. These must be dealt with in the JCT contract. Now, lawyers aren't expecting you to become mind readers or predict the future, but there are some things that you can say are possible. If you're in a mining area, sinkholes. If you're in a flood zone, flooding. The way the world's going at the moment, and having had a ridge tile fall on my car from the house recently, we can assume that storms are going to get more, so storm damage. All right. So there are certain things we can say are in the scope of our imagination that could possibly happen. So therefore, it would be remiss of you not to include these or have that force majeure, but for the act of God, in there. And then who may be responsible, or is it a case of insurance? Is it a case of joint responsibility or negotiated settlement? Okay. Other things that can be found in buildings, such as asbestos, so if you're renovating a building, coming across asbestos, okay, well, what do we do with that? Who's responsible for getting in the specialist contractor? Obviously payment has to be made. Does the payment fall within the scope of the investor? Does it fall within the scope of the builder? Have they taken away too much of a wall to actually get to the asbestos, etc., etc.? Foundation problems and planning delays as well are things that are in the scope of imagination. If responsibility is left vague, contractors may pass unexpected costs back to you. The secret of any contract is clarity. I've just been marking students that have been providing a legal opinion, and the most common thing I've said in their marking was precision is key. And it's the same with every contract. The more precise you are, the more protected you are. Quite often, people will leave the clauses vague and they will not amend them. At that point, if something goes wrong, sod's law, then the ambiguity in your wording will actually leave you open most of the time. Does that make sense? Yeah. Failing to negotiate termination rights. JCT contracts do not automatically give the employer or the investor easy termination rights. If a contractor is underperforming, you could be locked into a contract unless a termination clause is clearly negotiated and set out in the JCT. Okay. It is a very common area. Now, when I was a county court advocate, some of these did actually come through to me, and that I would say was as regular as clockwork. The termination. We have a dispute over this. They've underperformed. I have a right to dismiss them. And then when you look at the JCT contracts, especially if you're looking at, one of the more complex one, so the standard building contract for the larger developments, you look at the contract and lo and behold, there's no termination clause, or the termination clause is so ambiguous you could drive a bus through it. Okay. So there are ways of amending your JCT contracts. So to protect your investment, you have to amend your JCT. And you focus on the key areas. Customizing the payment terms. Ensure stage payments match your projected milestones rather than arbitrary time frames. I have spoken to a builder on behalf of a colleague, and they were literally going, "Oh, well, that could be 4 months. Yeah, that could be 6 months after. And yeah, well, we'll be in the summer by then, so it'll be a bit quicker. Yeah, it'll be 2 months after that." He was not happy when I turned around and went, "No, actually, you've got 9 weeks for this, you've got 17 weeks for this, and you've got 19 weeks for that." Okay. So those payment terms need to be written into the contract. Clear retention clause to hold back a percentage of payment until work is completed satisfactorily. Okay. People don't think that is capable in JCT. Yes, it is. And if memory serves me correct, on the standard JCT, it's somewhere around about page 19.
Is it so is it typically 5-10% for every payment is clawed back, or I guess you can do what you want, but typically on the same example where I'm turning this 3-bed house into a 7-bed HMO and spending 150K on a bill there.
Yeah, so it is usually between 5 and 10%. The most common percentage that is mooted is 8%. Why that is, I don't know. But having spoken to a few people, yeah, 8% seems to be the
If I knew that, Tony, because when I had discussions with my builders back in the day, it never had anything like that, So I was like, oh, 5%, and I should have pushed for 8. At the end, it's all incentivizing, and it worked well. But it's
yeah,
interesting that the benchmark is 8. I didn't know.
yeah. I mean, I am going by conversations that I've had. There is no set percentage. Okay, when you get to the massive constructions, I mean, Richard Clapson will tell you, with things like Terminal 5 at Heathrow, then yes, that percentage is absolutely crystal clear and everyone knows what that percentage is. But for the smaller projects that we would be involved in, it's between 5 and 10%, and that comes down to negotiation as to what you agree with your builder, etc. Okay, but as you said, and incentivizing can be a very useful tool.
But I don't know if everyone understood but it's actually really important, and you get the builder to prioritize to come and finish the work, rather than run around to the next big thing, 'Cause it's
Yeah,
very common that they've been paid now, and you've got all of the snags and things to finish. You can't move, you can't move furniture, you can't get tenants in, and they've moved on to other things, to their next big thing, and you can't get all of them. So by clawing back 5% to every payment at every milestone, at the end they've got maybe it can be 2,000, 10,000 pounds that they're only gonna get once you sign off the snagging list, basically. So they're really, really keen to. This is their profit for the project, basically. So or
easily.
have the profit of the project. So they want to go on holiday in the summer. So they are really keen to get this payment sorted. So.
Yeah, and it is really important to have that and so that it is you or someone you trust, i.e. your project manager, that has got to be signed off by you, and not an agent. Okay. Strengthening your delay protection. I mentioned earlier adding a liquidated damage clause, specifying a daily or weekly penalty if the contractor fails to meet the agreed deadlines. The danger is when you write these into a contract is you start putting more than sort of two in there. It starts going, oh yeah, well, if you don't meet this deadline, this is the penalty. If you don't meet this deadline, this is the penalty, and it starts going on ad infinitum. So there has to be an absolute backstop. So when you do these penalty clauses, the liquidated damage clause, there is usually, and there is space in JCT for you to make that a final. So yes, a couple of chances, but then an absolute final, and then payments are withheld, etc. If there are extensions of time, limit the contractor for extra time due to minor issues. So you need to clarify that, and the contract is a place to do it. Defining the scope of quality, you need to do this really clearly. As I mentioned, I mean, Guillaume, Sam, and I presume you've seen his schedule of works. They are absolutely, pinpoint precision. The more detailed you can be with the specifications of materials and workmanship standards, the better. This may seem very onerous, but by all means, look up Sam Carter online and look at some of his projects. To get that standard of finish, you need to put the work in by specifying exactly what you want, how you want it, where you want it, and why.
So picking up on Sam, so I think if you go back in the recordings, we had Sam on one of these sessions, and I believe he offered there was some giveaway or something, some QR code, and you could get a copy of his schedule of work or something like that.
Yeah.
And then when you upgrade to Property Filter yearly plan on the Property Filter Plus, I share mine, which are similar as well. So, and that's just giving you a head start. And then exactly as Tony says, you want to be super clear, because if you say to a builder, I want a kitchen in this room with a few sockets, it could turn around and go for the 500-pound kitchen, which has got the same number of doors you have on the drawing, and stick 5 sockets above the door, and it wouldn't be a breach of the contract, right? So you want to be really specific, because then you are liable for any rework on the other side.
Yeah. One place I walked into not that long ago had recently been refurbished, and you had sockets on the wall like that. And I said to the owner, I said, "Oh, Sparky didn't do a good job." And bless her, she turned around and went, "Well, yeah, I can't do them because I didn't specify in my schedule of works what was needed and where." And so they weren't in breach of contract. It sounds absolutely nuts.
You really, really want to specify every socket or how you want them. If it's above the desk, below the desk, just gonna save you so much time. You don't have to go on to be on site every day to show things and write things down. Just do it once and it's always the same everywhere. So again, these resources you've got access to, make them yours. It's a big game changer for your referrals. So you move from having to be full-time on site doing one project at a time to do 5 or 8 all in the same time. So
yep, absolutely. Also with that, something I've got to mention, defining suitable substitutes as well.
what do you mean?
So if a material isn't available, so if your gold-plated socket isn't available, and there's a timeline, so the builder, because you've written into the contract that he can't go over time, the builder is going to have to wait for 17 weeks for it to come from Dubai. then obviously he's going to come to you and say, well, I've got an alternative. So a suitable alternative, if you've got stuff that is different, if you're getting something that's completely non-standard, if that is going to be delayed, then an alternative for you to remain on time, and also your builder is going to press you to remain on that timeline as well, then specifying a suitable alternative as well. Okay. But that depends on your fixtures, fittings, what exactly you want in that building. If it's something that's regular, it's standard, regularly available, then an alternative probably won't raise its head. But if you've got something that is a bit unique, a bit different, then if they cannot get hold of it, and for your project to remain within the timeline that you've specified in JCT, you have to be fair to the contractor and to yourself and specify a suitable alternative. Okay.
So for this is it right? So what I used to do is we say this is the socket I want. This is the link to a typical place to go and buy it, or similar, subject to approval by
Absolutely.
the employer, and then they'll have a form where they'll be able to. It's just a standard form we produced where they'd go and request for material approval, and then you could just fill the form with the new references, and they would put some narrative to say, and look, we just print it, and the builder will just do it by hand, sometimes.
Absolutely. That way your builder is protected for not putting in the standard that you required in your schedule of works. Okay. Um, Clearly state who's responsible for unforeseen conditions, so contaminated land, asbestos removal, etc. Most of the time, I would suggest using a lawyer for that particular clause in the least. Okay. Um, because if it's something you're not aware of, you don't know, then to protect yourself, to ensure that those risks are properly managed, then it would be worthwhile speaking to a lawyer at that point.
To me, on this, like we talk a lot about risk allocation and things, and so that's going back to my pre-property investor career where I used to be like a contractor it's more in the like repairing bridges and infrastructure and things like that. And I was going and basically selling all the risks. If I would go and acquire all the risks, and I would
Uh,
have this huge reach. So basically, the public client would love certainty, and I would have this huge matrix where I'd say, oh, the weather risk, this is the risk, the likelihood of us not being able to work for many days, the cost of it, and then I would multiply, and I would have this huge thing, I would basically make millions for the guys I were working for, just by being a bit aggressive on risk like that, by being open about I'm taking all the risk on this, but this is the cost for it, and being quite transparent. But I don't know, with more residential refurbs and commercial conversions, HMO conversions, and things like that. Because I sit now on the client side, I don't I don't want someone to do this and make load of money by yeah, if there is asbestos in your granny annex, it's I'm putting something in the risk pot for it, and then it just piles up, and you could be in the tens of thousands of risk that's never going to materialize. So I tend to be on the client side where I take more of the employer risk, the client risk, the site condition risk, the weather risk, and then all the things that are not basically in the contractor's control. The fact that there is some asbestos when they start to leave some floorboards or they uncover some things that nobody knew about. I keep it as my risk, and I keep their price low, and then there will be a variation where they'll be paid for extra work at
Yep.
the time. But
That
the only
is
thing on
quite
them
often,
would be like site security and things like that.
yeah, and that is quite often the way around this particular issue of unforeseen conditions. So being open to that negotiation and being sensible and realizing what risk you can take on, um, and what risk you need to mitigate to other people. So it is a case of negotiation around this, and also, using your networks. And with your background, Guillaume, I know who I'm going to come to. um, Contractor warranties, ensure they're included as well. Make them liable for defects even after project completion. That seems quite mercenary. I know it does. However, if you discover something, you know, so you walk into your property, it's all sparkly and new. You get a tenant in there, and all of a sudden there is a defect from, when the contractor was in there, and you've got no warranty in place. Who does the cost fall upon then? It falls upon you. So having that contractor warranty in place. I've just seen Lars. Yeah, there are standard warranties, but again, if you have an unusual building, so I was talking about the arts and craft building in Canterbury, there are unique aspects to the arts and craft building. So if they're going to do some work around, supporting an arts and craft really heavy fireplace, and they don't do it correctly, then that will probably fall out of your normal, outside of a normal warranty. And so you ensure that you have a contractor warranty in place as part of your JCT. It really is belt and braces. Okay, does that answer your question, Lars? Yeah, yeah, brilliant.
Someone was asking, is it typically 6 months? Is it 1 year?
Um, right, most warranties that I've come across are usually around about a year, usually a year. I have heard of 6 month warranties, but to be honest, with buildings, I would look at a warranty for longer than that.
Yeah. So I think new builds are usually 2 years, isn't it?
Yeah, new builds are typically 2 years. I I do know of one contractor that recently was trying to do a month warranty. Yeah, for some reason he's not got any work. I don't know why.
Crazy.
Yeah.
And on the other side of that, if you know where not to set up a construction firm, it's in France, because you've got mandatory, statutory 10 years warranty on everything you build and refurb. So I'm telling you, the builders you can't afford to do a shit job, because 3, 4, 7 years down the line, it comes and bite you. So it's quite strict. Yeah.
Yeah, wow. Right, I'm off to France. See you later.
Yeah, if you want your own place, but not to build, yeah. Mm.
Yeah. Um, Clear termination rights. I mentioned those earlier, but this is one of the things that people don't put in there. Add clear termination rights so you can exit the contract if the contractor is underperforming. Um, it becomes difficult when you're bound to form a relationship with the builder. Yeah, it's almost inevitable. And people feel quite mercenary when they activate a clause like this. But are you running a business or running a friendship bureau? And that, unfortunately, sometimes, as I found with my business, you've got to be that strict, because ultimately it's going to cost you money. And that's the last thing you want. You're running a business, you run a business for profit. So therefore, clear termination rights have to be in the JCT. It is in the latter part of the JCT, and people, I'll be honest, by the time they've gone through the booklet, are usually bored. And then they flip to the last page and sign it. Please don't do that. Read your contracts. If you are not aware of a contract, you can still be bound by it. Okay, it's part of what I say in my talk. Okay, even the only time a court would possibly ignore a clause or say it doesn't apply is if it's written in the finest possible print going, and it's buried at clause 497. Okay, they have to be reasonably clear, the clauses, but if you don't read them, you don't amend them, in something like a JCT, which is standardized contract, a court is going to look at you and go, well, you should have known it was there. Okay. Define the process for dispute resolution. Alternative dispute resolution, ADR. Courts are overloaded at the moment. You've probably seen that on the news. Okay. The courts are now pushing for ADR to happen before anything comes to a court. So negotiation, arbitration, mediation, expert determination, these are all alternative forms of resolution for a dispute. My subject at Canterbury is employment law. Now, before anything goes before an employment tribunal, it must go to ACAS, the conciliation organisation, and you must have a certificate from them. That's before the tribunal will even hear your case. So ADR is a way of, avoiding the courts, as you put, Guillaume.
So who are the bodies you put as a mediator in this?
So there's ACAS, the arbitration and conciliation. Oh, I forgot what the A is now. So they are a
Yeah, like
professional body.
association or something. Yeah.
So there are other associations out there.
Mm.
There are mediation clinics. Canterbury Christchurch University run a mediation clinic, and they've dealt with building disputes. So that's law students supervised by a lawyer, and they will run the mediation for you. So there are multiple places where you can go to obtain mediation. There are independent mediators, arbitrators, conciliators. Okay. And there are organizations. You can even go to the Citizens Advice as well.
Mm.
And they will point you in the right direction. But your local law society as well.
Okay.
Most law firms will have a mediation or a mediator or arbitrator within their ranks, and they will be able to perform this service for you. But the courts, so this will go to a county court, and the district judge will, the first thing he will do if you turn up without having attempted any form of mediation, will go try. So you walk in there,
Mhm.
you barely sit down, and he will adjourn it for mediation. Lo and behold, your trial is now, or hearing is now 6 months down the line, and obviously costs build up for you.
Mm.
So looking at ADR as a process to build into your contract avoids the lengthy and costly legal battles quite often. ADR is a hell of a lot cheaper than litigation. Okay. And trust me, the Ministry of Justice and the courts and the judiciary are wanting more of this because our court system is absolutely overloaded. Okay. So it's something to consider. So, JCT contracts are essential. It's a structured legal framework for construction and must be understood. Okay. And it must be amended as well.
So bit of a segue from your comment here and what Jamie and Said were saying earlier. So can you tell a bit more about typical project size or for you to pick one or the other? If it's one, and on the five you said typically for the typical investors doing buy-to-let refurbs, extensions, HMO conversions, and maybe a commercial to resi on the high street with a shop and two uppers
So
around that. And also if people need help, who do you go to set these up? Or when you say they need to be understood, can I sit down one afternoon and figure it out? How does that work?
Yep. So I've got a couple of free resources for everyone. So I'll let you know my email address in a minute, and you can link with me on LinkedIn. So I've got a typical amendments, and just find the. So I've got an amendment guide, and where's my other one? Oh, I've lost me the other one now. Yeah. And a contract checklist. So I've got those free resources that I'm happy to send out to people. So just contact me either via email or LinkedIn.
Sorry,
But
where's your, did you put your email somewhere? Sorry,
yeah,
Tony?
in the chat. But in the
Um,
subject line, please, please, please put JCT talk and Deal Finders Corner so I know it's
yeah.
coming from this. Okay.
So I don't know if you maybe didn't press on enter or something. It didn't come to my end. I didn't see your, don't see your email.
So 6.
Oh,
No,
okay, got it. So
no.
that's T Power. So for Tony Power, T Power at empowermenttraining.co.uk. Okay, cool.
And if you give me 2 ticks, I'll stick my LinkedIn link in there.
Cool. Subject line, Anthony will be JCT contract props filter talk or deal finder corner talk, just so Tony
Yeah,
can relate it back to here and put it into context of the conversations we had.
that would be brilliant.
Yeah, because I'm sure, yeah, you get a lot. Yeah. So
Hang on, my LinkedIn.
have you got, I think it'd be really beneficial with the work you do, Tony, or for investors, is having a like a chart with like the different your typical project size and
Yep,
the characteristics, and then on which like which contracts to pick from there in the main, with I'm guessing some small print that's some disclosure, on it, but and then what's the process? So I think people were asking, can people just go and buy a JCT contract or download a PDF somewhere, print it, and do something with it? Do I need to have someone set me up? Is it going to cost me some money? How does that work?
yeah, they do cost. There is a cost for JCT contracts. I'm happy to put together a table as to the size of projects,
Oh, yeah, yeah, yeah.
what JCT goes with it. I can also provide your listeners with, yeah, I can tell you where you can get hold of them and what sort of prices they are as well.
Okay.
That's not a
So,
problem.
so let me know, but maybe I've done this wrong, right? But that's a few years ago now, so it's like the GFK files can go public now. But I don't know where I found it, but I went for, and I guess because I have this experience in contract managing before, I found just the template of it, and I filled the blanks and I kind of had the conversation with the builder at the time. But I should have gone to someone a bit professional to do this for me. What is the function or the job title of someone who could have helped me set this up?
It would be a lawyer.
Okay.
Yeah. So, what have you?
Yeah, Simon saying, do we employ an administrator to complete this?
Sorry, say that again, Guillaume. I'm trying to
Yeah.
find the form I
Uh,
was talking about.
no, no, no worries.
Yeah,
You
sorry, say
want
that again, Guillaume.
No worries. Yeah. Simon was asking, do we employ an administrator to complete this? So it's just, I think there's a few questions, and I had the same question on the clarity of around when do I employ who, basically, to help me with this.
Yeah. So when you start, so the JCT is quite early on in the process. Now, you can do them yourself. There's nothing stopping you doing them yourself. However, there are legal terms in there. And so there are legal consultants like myself out there that will happily help you complete these.
Okay. Of course, I didn't. But I'm sure. Yeah, I didn't think. Obviously, yeah, it could help. Yeah. I'm sorry.
Yeah. So yeah, I mean, I can help you do those. Um, Beware with legal consultants. Okay, even though I am one, my history and background is on LinkedIn for everyone to see, and it's verifiable because I'm regulated by Silex. There are legal consultants out there that are graduate law students who don't have insurance and don't have the legal background. A legal consultant isn't necessarily regulated. Hence, I joined Silex, even though I'm affiliated with the bar in England and Wales, and I'm a member of the Kent Law Society, so the regional law society. But yeah, there are people out there that are charlatans, I'm afraid. So please do your due diligence if you're going to employ someone like myself. Okay. Um, yeah. So yeah, I can quite happily provide. I'll let you know when I've got the table put together and where you can get them and who you should speak to for completion. But if you are unsure, I always will say go to a legal professional. Okay, so go to a lawyer, go to your local solicitor, go to the larger firms, not the backstreet firms. That's no, I'm not casting aspersions on any legal colleagues. It's just the larger firms will have someone with that form of expertise. The smaller solicitors, the high street solicitors, may not. It may be only the practice manager and one other solicitor. And as a generalist, they may not understand a JCT contract. The larger firms will. Okay. Does that make sense?
Yeah. Okay.
Yeah.
Um, Ian is having a really good comment. You haven't suggested asking a QS or an architect to assist. Is there a reason why? Good
Um,
point.
so quantity surveyors and architects, it depends on their experience. It depends on whether they've used them before. If you have an experienced quantity surveyor, so his name's just slipped from my mind. The former Kent Pin host, Martin Rapley.
Martin Rapley. Yeah.
Yeah. So someone like Martin, who is a property investor, former Rick surveyor, yeah, he's more than competent at filling out JCTs. Okay. Um, so it depends on the person. If they have experience filling out JCTs, yes, by all means, they can guide you on that. Architects, not so much, unless they are someone who's a property investor themselves and have got their boots dirty, if you like. Then the likelihood of an architect being able to fill out a JCT is minimal.
Mm,
Okay, it is a legal contract. It's really outside of their scope.
okay.
Yeah,
Yeah, I did work with a few QSs in this previous function before, so yeah, that makes sense.
yeah,
And as you say, with experience and stuff, if they go and manage a lot of contracts, all the measure all the variations and stuff, they deal with the whole enforcement of it, they should know that. So yeah, good point.
yeah. I mean, a really good project manager who's been around the block a few times, they should be more than competent at helping you fill out your JCT as
Mm.
well.
Yeah, I would say so. I would say that it's quite simple. Me, I like this stuff. I find it sexy and interesting. So I know it can be boring for most people, but it's not really that complicated. So go have a look on the JCT website. It's the most common used type of contract. Even if you're a homeowner, you can use it for your own home extension. So you don't, usually it will be more builder led. And they will like
Yeah,
bring it to the homeowners and things like that. And it's not that complicated. And it's just that most clauses are standard because they're always the same all the time. So when you are doing multiple projects with multiple different builders, you know that clause 32 is always about this. You know that clause whatever is always about that. So
absolutely.
you don't have to recreate the wheel, reinvent the wheel every time. So it makes it really, really simple. So just go through it. Go through it. We'll get from Tony this chart, and I'll share the table of the different size of projects with the typical different size of things with his details, and I put it in the community,
Yeah,
app. And then just for me, it's interesting stuff and it's good management. Uh, you can get some advice to set it up in the first time, and then you'll build confidence to run with it. I believe none of what I say is advice, by the way. And it just will give you a lot of sanity, as Tony was saying, is just a lot of clarity. What was the sentence you had, which I really liked? Um, the more precise you are, the more protected you are, and then it just remove a lot of uncertainty, prevents having you sockets on the ceilings and above doors and things like that, which I've seen, right?
Yeah,
So
same here. Same here. I mean, the people are always worried about contracts. Hence my talk on the pin circuit. I do it as if it was, have I got news for you? And I try and inject a bit of humor in there. Yes, they're important. Yes, you need to read them. Yes, you need to amend them to be fit for purpose. Because if a contract isn't fit for purpose, it has no standing and you don't have any recourse. But as Guillaume quite rightly said, JCTs, the whole idea of these being brought in back in the 1930s was to make things easier. And they do. They have standardized most of the clauses. So as Guillaume said, you know exactly what clause 32 is. But you need to keep an eye on the ones that are variable and make sure you are as clear as possible. Precision is key. It really is. Okay. And that precision will, even though it can be boring, it will save you a hell of a lot of money. Okay. Just to end with one final little horror story.
I was going to ask if you had a closing sentiment or something. Yeah, so.
So, this is when I was starting to understand what JCT contracts were. I was in court. I was dealing with an investor and a builder. I was for the investor, and the builder was very, very switched on. That switched on that he walked in with a barrister from Great James Street Chambers in London, a top legal 500 chambers. And the investor looked at me and went, "Are you a barrister?" Well, no. Oh, we've got a problem then. Yeah, well, we didn't because I won. However, before I found a slight flaw in the argument against us, the barrister was proposing that the delays due to the JCT contract not being filled out correctly, the delays and damage to the builder, so they wanted damages of £25,000. The judge was prepared to award a cost order against us, so paying my legal fees and the barristers. This was a 4-day hearing. So the cost order in total was £37,000. Have a guess how much your project was worth.
8.
No, it was just shy of 100,000.
Okay.
So by this time, yeah, no one's made anything. Thankfully, though, the barrister had missed something. And this is why I love force majeure clauses, because there was an issue that was unforeseen that my client did actually, it was the only clause he filled out correctly on the JCT, and the builder failed. Totally, utterly failed. And the barrister missed it. So I managed to flip it round and the cost order went the other way. So,
Very good.
yeah, the devil is in the detail, as one of you has already said. Okay.
Indeed. I believe we answered all the question here. Thanks so much, Tony. I know you are very, very busy guy, always giving lecture and sharing your wisdom in lots of places and between the corrections, the exams, and all sorts. It's you're quite been quite hard to find. So I'm really happy we finally managed to get you here. And
Well,
thanks so much for sharing this. It's guys, important subject, a bit boring for some, but it's really where a lot of the money is by just de-risking things, you know. A lot
Yeah.
of the uncertainty in property is around those refurbs and you know, most people I see get into these refurbs and builder relationships do it in a we just go in the wrong foot and with just piles and piles of uncertainty. And these are just and it's very simple. You know, once you've gone through it once, it honestly it's simple, like it's piece of piece, right? So really easy to understand, and then it becomes quite common for you to use, and you'll see how the peace of mind you'll have around all of this. It's where the biggest risks and headaches are in property, and you can waive all of that, by just being more organized on this. So thanks so much, Tony, for sticking with us quite a bit longer than we managed to book you for. So it's great.
No,
Thanks for
absolute
that.
pleasure. Absolute
Look forward to yeah, I'll take your offer on and get those resources. And guys, do go and get Tony's email just now, and then I'll be in touch with Tony as well, and we'll share this graph about different JTC contracts for different type of projects in the community.
Yep.
Do you want to add something, Tony?
No, and I'm more than happy to discuss JCTs with people. So drop me a line and yeah, we can always arrange a discussion, and always happy to come back on to answer any further questions.
Yeah, thank you. Is there any other area of laws in property you cover, like with people doing JVs and loan agreements and stuff like that?
Yeah, JVs, contracts. So yeah, anything to do with the legals, give me a shout.
We
'Cause if
might have
any-
we might make you come back to talk about
yeah,
JV contracts and stuff. Yeah.
yeah, by all means, not a problem at all.
Awesome. Well, thanks
Trust
so
me, if
much.
I don't know, I know someone who does.
Okay, awesome. Tony, everyone, thanks so much. Thank you for joining us. I hope you enjoyed today's Deal Finder Corner. Do take on Tony's offer for those resources. Do find his email in the chat before we close the call, and then email him. We get a copy of that. In the meantime, visit Property Filter, log on to your Property Filter account, and follow the steps. You know the drill, right? Have an endless supply of deals, join the top 1%, and become a high achiever. Deal Finder. I hope you enjoyed today's Final Corner, and I look forward to seeing you next week, where we'll talk about networking and life lessons with a very special guest. Thank you.
Brilliant.
See you. Bye bye.